This is the 3,115th meeting of the committee, and we're here to discuss the fourth periodic report of Israel. The usual approach will be taken. That is, the delegation will make its statement, colleagues will ask questions, and then the delegation will respond. The first round of questions will be 1 to 12, and the second round of questions will be 13 to 26. So without further ado, I invite His Excellency Mr. Manor, Ambassador Manor, the permanent representative of Israel to Geneva, to make his introductory statement. You have the floor, sir.
Thank you very much, Mr. Chairperson. Mr. Chairperson, distinguished committee members, ladies and gentlemen, I am honored to be here today to present the State of Israel's fourth periodic report under the International Covenant on Civil and Political Rights. On behalf of the Israeli delegation, I warmly welcome this opportunity to discuss Israel's effort to fulfill its obligations and to share some of our achievements, experiences, views, and challenges. Israel places great importance on respect for human rights. Like other democracies, it is governed by the rule of law and maintains the separation of powers between the executive, legislative, and judicial branches. Israel has an open and dynamic society, as well as a vibrant and active civil society. Fundamental human rights protections are afforded to every individual, preserved by a series of basic laws which have a quasi-constitutional status and relate to all aspects of life. Israel's courts are both empowered and willing to intervene and impact public policy. Human rights are given added value and are further entrenched into domestic law by the Israeli Supreme Court. Since the establishment of the State of Israel in 1948, the Supreme Court has played an important role in the protection of human rights. The Court's decisions have protected all basic liberties as fundamental values of the Israeli legal system. Israel's ratification of 7 core UN human rights conventions reflects our country's strong commitment to the important protections established in those conventions and to the additional monitoring mechanisms. Israel highly respects and values the work of this committee and of other UN treaty monitoring bodies and gives serious consideration to its conclusions and remarks. It sees this monitoring process as an important element to promote and protect rights internationally and domestically. I am very pleased to present our high-level delegation composed of many experts from all relevant ministries in Israel, experts who are personally involved and well familiar with the various relevant issues and processes. They have consequently the ability to provide substantive responses to the committee. The members of our delegations are from the Ministry of Justice, Ms. Emi Palmor, Director General of the Ministry of Justice, Dr. Roy Schoendorf, the Deputy Attorney General for International Law, Attorney Hila Tene-Gilad, Director of Human Rights and Relations with International Organizations, Attorney Daniel Marks, Administrative and Constitutional Law Department, Attorney Asaf Radziner, the Legislative and Advisory Department, and Attorney Nadim Aboud, Assistant to the Director General of the Ministry of Justice. From the Prime Minister's Office, Mr. Ayman Saif, the Director of the Authority for the Economic Development of the Arab, Druze, and Circassian populations. From the Israel Defense Forces, Colonel Noam Neumann, Director of the International Law Department. From the Ministry of Foreign Affairs, Ms. Liron Bar-Sadeh, Director of the Human Rights Department, Mr. Omer Kaspi, Deputy Head of Mission, Permanent Mission of Israel to the United Nations and international organizations in Geneva, and Attorney Orit Kremer, Legal Consultant to the Permanent Mission of Israel to the United Nations and international organizations in Geneva. Since the submission of its previous periodic report, the State of Israel, while facing constant security challenges, has taken significant steps in several fields in order to promote and better implement the Covenant on Civil and Political Rights, as will be addressed by my colleagues shortly. Mr. Chairperson, distinguished committee members, on June 12th, 3 Israeli teenagers were kidnapped by Hamas terrorists. Since the kidnapping, southern Israel, followed by most of the country, became a continuous target of ever-increasing rocket and other terrorist attacks from the Gaza Strip, including cross-border attacks and various attempts to kill and kidnap civilians via tunnels that penetrated into Israeli civilian residential areas within Israel's sovereign territory. Israel has a duty to protect the lives of its citizens, the same right to life which in fact underlines the ICCPR and constitutes its very fabric. Before launching Operation Protective Edge, Israel showed great restraint by calling for the cessation of the rocket attacks. Hamas's response was to escalate its cross-border attacks with more than 300 rocket attacks on Israel's civilians in the days leading up to the operation. Operation Protective Edge, which lasted 50 days, was forced upon Israel by the Hamas, which deliberately acted to inflame the situation. The rise of Hamas and the ensuing violence caused the Israeli public to doubt whether its sacrifices for peace could be reciprocated. The continued presence of a terrorist government in Gaza and its constant attempts to gain power in the West Bank severely undermine a constructive dialogue between Israelis and Palestinians. Hamas is a radical Islamist organization similar to Al-Qaeda, ISIL, or Boko Haram. It threatens the human rights of Israelis and Palestinians alike, both on the West Bank and in Gaza. Israel remains committed to peace. We are willing to make historic and painful compromises to realize the creation of a demilitarized Palestinian state living side by side with the Jewish state of Israel. Israelis and Palestinians will have to work together to resolve numerous complex problems. This will only be possible if our work is built on a foundation of truth, mutual recognition, and security. It will be achieved only through direct bilateral negotiations between the parties. Mr. Chairperson, distinguished committee members, as an expression of its appreciation for transparency and dialogue in a democratic society, Israel cooperates with various international and domestic bodies and NGOs to deal with human rights issues. We are here today with a firm belief that this dialogue with your committee provides Israel with an important instrument to further improve its mechanisms for a better implementation of human rights. With your permission, Mr. Chairperson, I will now give the floor to my distinguished colleague, Ms. Emi Palmor, Director General of the Israeli Ministry of Justice. Thank you.
Honorable Chairperson and committee members, it is a great honor for me to present to you today Israel's 4th periodic report on the implementation of the International Covenant on Civil and Political Rights. The report is the product of a broad collaborative effort by many Israeli government ministries and bodies. We are also grateful to have received useful input from NGOs for part of this work. Today, I would like to discuss some of the significant developments in Israel's ongoing efforts to protect and promote civil and political rights from 2011 to 2014. As we hope to show, the State of Israel has carefully studied the committee's previous concluding observations, and I am pleased to inform you today that many of the areas of concern raised by the committee have seen great improvements. At the outset, before addressing the substantive aspects of the report, I'd like to touch upon some key points regarding the process that led up to its preparation. First, we are pleased to inform you that since 2012, the Ministries of Justice and Foreign Affairs are participating in a project initiated by the Minerva Center for Human Rights at the Hebrew University with the aim of enhancing the cooperation between state authorities, scholars, and civil society organizations in the reporting process and in the implementation of human rights conventions in Israel in the best possible manner. The first periodic report that was chosen for this project is Israel's 4th periodic report to this committee presented here today. We are fortunate in that sense to have a very open and dynamic society with a very active media and a court system ready to intervene to remedy wrongs. During the compilation of the report and the preparations for this meeting, we conducted intensive and in-depth discussions on numerous issues relevant to the committee and debated whether the measures taken in Israel have been sufficient and what more should be done. As such, the efforts that went into the compilation of the report and the preparation for this presentation provided, in and of themselves, an invaluable opportunity to conduct rigorous internal assessments and to obtain both a macro and micro level perspective on Israel's implementation of the ICCPR. I have to say that following these deliberations, we are quite proud of the progress made thus far. We, however, also came out with a unified conviction that more needs to be done. As an additional example of the serious manner in which the State of Israel considers human rights matters, it is worth noting the establishment in 2011 of a joint interministerial team headed by the Ministry of Justice, the Deputy Attorney General, dedicated exclusively to the review and implementation of the concluding observations of human rights committees, including those of present committee, naturally. In addition, since our previous meeting with the Distinguished Committee, Israel has ratified in 2012 the International Convention on the Rights of Persons with Disabilities, which serves as an additional layer for protection of human rights in Israel. Mr. Chairperson, against this backdrop, allow me to briefly address some of the developments regarding the promotion and protection of civil and political rights in terms of legislative, judicial, and administrative efforts. Since the submission of our previous report, all branches of government have made a concerted effort to protect and promote civil and political rights in regards to all populations in Israel. With respect to the legislative arena, here, Israeli legislation from recent years reflects a more mature and sophisticated ability to use legislative tools in a comprehensive manner in creating social change in sensitive areas such as those are discussed in the report. A few recent examples are the enactment in January 2012 of the government-approved expansion of adequate representation for persons of the Druze community in the public service, legislative amendments. This law expands the already existing affirmative action plan applicable to persons of the Druze community in government corporations as well as municipalities. On June 10, 2013, the Knesset approved Amendment number 26 to the Religious Judges Law, Dayanim, which provides that at least one of the two representatives from the government, Knesset, and the Israeli Bar Association of the committee in charge of appointments of religious judges for the religious Jewish courts in Israel must be a woman. This amendment is intended to provide better representation for women in this important committee. Recently, in March 2014, the adjustment of works of art, performances, and broadcasts for persons with disabilities law was enacted. This law clarifies that making adjustments to work of art, performances, and broadcasts in order to make them accessible for persons with disabilities is legal and does not require the approval of the creator or the copyright's owner, and no royalties are payable for such adjustments in accordance with the provisions of the law. Also in March 2014, the Knesset approved Amendment number 4 to the Pupils' Rights Law. This amendment added sexual orientation and gender identity to the list of prohibited grounds of discrimination against pupils. The amendment imposes a punishment of 1 year imprisonment or a fine for any person who commits such discrimination. In the judicial realm, Israeli courts, led by the High Court of Justice, have continued to play a crucial role in anchoring human rights and promoting them throughout Israeli society. In Israel, any person, regardless of citizenship, residency, or status, in addition to non-governmental organizations as a public petitioner, who feels that his or her rights were unlawfully denied or infringed, can and often do petition the High Court of Justice. The court may also examine the question of respect for human rights in the course of active hostilities. Such petitions are heard on an expedited basis, sometimes within hours. Israel's Supreme Court has received worldwide recognition for its active role in promoting human rights. A good example of the court's central role in the promotion of human rights is the landmark decision of September 16, 2013, in which the High Court of Justice ruled in a petition filed by several NGOs regarding the constitutionality of Amendment Number 3 to the Prevention of Infiltration Law, Offenses and Jurisdiction. This amendment had originally entered into force in January 2012 as a temporary provision for a period of 3 years. Under Section 30A of the law, as amended, a person that enters Israel illegally could be held in detention for a period of up to 3 years, subject to certain exceptions. An extended panel of 9 judges ruled that holding persons for such a long period of time constitutes a material violation of their rights, including liberty and dignity, as enshrined in the Basic Law, Human Dignity and Liberty. The court determined that this violation does not meet the proportionality criteria contained within the limitation clause of the Basic Law and was therefore unconstitutional. The court annulled Section 30A of the law. Following this ruling, the government enacted Amendment Number 4 to the law for the purpose of complying with this court decision. On September 22, 2014, an extended panel of 9 judges of the High Court of Justice ruled in a further petition on this matter, and 6 judges ruled that holding persons for up to a year in detention constituted a material violation of their rights, including liberty and dignity, as enshrined in the Basic Law, Human Dignity and Liberty. The court determined that this violation did not meet the proportionality criteria contained in the Basic Law and was therefore unconstitutional. Consequently, the court annulled Section 30A of the amended law and ruled that the entry into Israel law applies instead. Furthermore, the court, by a majority decision of 7 judges, annulled Chapter 4 of the amendment, which established the new Cholot facility and stated that it violates the rights enshrined in the Basic Law, Human Dignity and Liberty, in a manner that does not meet the proportionality criteria contained in the Basic Law and was therefore unconstitutional. This annulment should take effect in 90 days. The duty to report to the facility every day at noon was also annulled, with effect on September 24, 2014, since it violates the right enshrined in the Basic Law, Human Dignity and Liberty, in a manner that does not meet the proportionality criteria contained in the Basic Law, and was therefore unconstitutional. In the realm of measures taken by the executive branch, since our last presentation before this committee, many positive developments have been made in order to advance and promote the Arab population. This include, among other things, 6 government resolutions allocating 5 billion Israeli shekel, which is 1.4 billion US dollars, for the benefit of this population, an improvement in the rate of employment, especially among Arab women, a significant improvement in the level of education of members of the Arab population, and significant improvement to the public transportation serving Arab localities. Our delegation includes Mr. Ayman Saif, the Director of the Authority for the Economic Development of the Arab, Druze, and Circassian populations in the Prime Minister's office, who will answer any questions you may have on this issue. Mr. Saif is a member of the Interministerial Committee for the Eradication of Obstacles to the Integration of the Employment of the Arab Population in the Public Service, which I direct. The Ministry of Justice sees the employment of members of the Arab population as a prominent issue on its agenda, with many resources devoted in recent years, as will be elaborated in our later presentation. I would also like to report that as of September 2014, following an agreement between the Minister of Justice and the Chief Justice of the Supreme Court, hearings of the Supreme Court on constitutional issues are publicly broadcasted and are accessible through electronic media, television, radio, and internet. This was done in order to increase the transparency and accessibility of these hearings and to allow the public to receive full and direct information about proceedings that affect the Israeli society. Also, on June 14, 2010, the government of Israel established a public commission of inquiry mandated, among the other responsibilities, to assess whether the mechanisms for examining and investigating complaints and claims raised in relation to violations of the laws of armed conflict conforms with Israel's obligation under the rules of international law. The commission was headed by former Supreme Court Justice Yaakov Tirkel, and included prominent Israeli experts and international observers. The Commission submitted its comprehensive report in February 2013. Among its conclusions, the Commission concludes that Israel's mechanism for examining and investigating complaints and claims of violations of the rules of the law of armed conflict generally comply with its obligations under international law. The Commission nevertheless made several recommendations for strengthening the Israeli system, including, inter alia, the adoption of domestic legislation, a number of structural changes, and the anchoring of existing policies in written directives and procedures. The recommendations made by the Commission are currently being studied by a specially designated committee appointed by the government in January 2014. It is worth mentioning that some of the recommendations in the Turkel report have already been implemented relate to matters in which Israel has already initiated on its own accord and before the issuance of the report, changes and modifications that are already in work process. An additional administrative development is my temporary appointment by the Minister of Justice to serve as the Director General of the Rabbinical Courts in Israel. This is the first time that this position is being held by a woman. The minister sees great importance in the identity of the person filling this position, since it entails not only administrative significance, but also substantive importance to the daily lives of millions of Israeli citizens. In addition, in June 2013, the function of Inspector for Complaints against Interrogators of the Israel Security Agency has been transferred from this agency to the Ministry of Justice. The inspector, also a woman, is now part of the Ministry of Justice, a move which bolsters the autonomy of this important office. It is hoped that this will result in a further strengthening of existing mechanism for the protection of human rights of security detainees. Mr. Chairperson, we are looking forward to a constructive and fruitful dialogue between the committee and our delegation. We have much to present to you today, far more than I have just briefly described, and we hope that the delegates, who are all high-level professionals in their respective fields, will be able to present and to elaborate on the report in all its details. Israel's position with regard to the application of the International Covenant on Civil and Political Rights to the West Bank or to the Gaza Strip were presented to this committee in its previous sessions and in the report. Having said that, today our delegation comes before you in the spirit of a fruitful and constructive dialogue, and we intend to address every question put before us, including questions relating to the West Bank or to the Gaza Strip. Our hope is that the heart of the discussion will be balanced and not focused completely on a discussion on the situation in these areas, given the enormous efforts Israel has made to fully adhere to its obligations under the Convention. I would like to thank you very much for your attention. I hope that by the end of the day you will recognize the level of seriousness in which Israel is taking its obligation under the Convention and addresses the remarks of the committee. Israel has spared no efforts to cooperate with the committee, and we hope that this session will provide us with the opportunity to conduct a candid and constructive dialogue with you. The ambassador has spoken about Operation Protective Edge, and I decided not to talk about it in a lengthy manner, but I would like to say a few things as well. A primary duty of the State of Israel, and indeed of every country, is to uphold and protect the life of its citizens, the same right to life which underlies the Convention and constitutes its very fabric. The State of Israel has had to direct many of its resources in furtherance of the protection of this basic right for all its citizens, with obvious security, financial, and social implications. The State of Israel makes ongoing efforts to find the best possible way to address such challenges while taking into consideration its international obligations, the welfare of its population, and basic human rights and humanitarian consideration for all sides. Our wish is that the committee will take all of this into account. I would like to reiterate that the State of Israel is a peace-loving state, and it is committed to achieving genuine peace with the Palestinian people. The government of Israel favors direct, meaningful, and good faith talks between representatives of the two sides based on a mutual respect and trust. I would like to use this platform to express our sincere hope that this conflict will be resolved in a respectful, mutually agreed manner, which will bring about peace and prosperity that are long due in the region while respecting the rights and interests of both sides to the conflict. Thank you.
Thank you very much, Ms. Palmore, and to Ambassador Manor before you. The floor is now open to my colleagues, and the first speaker on my list, again, to recall, we're dealing with issues 1 to 12 at this point. The first speaker on my list is Mr. Flinterman. Mr. Flinterman, you have the floor.
Thank you, Mr. Chair. Mr. Chairman, I join you in warmly welcoming the delegation from Israel and in expressing my appreciation for the information given in the report and this morning in the oral presentation of the report. I'm very pleased that Israel accepted the new reporting procedure, often called the LOIPER procedure, the list of issues prior to reporting procedure, a simplified reporting procedure which helps so much expedite the work of the committee and, I think, of the state party. When our committee last met in July 2010 with the delegation of Israel, it highlighted in its concluding observations 4 areas on which it asked the state party to report within 1 year. That was the issue of the blockade of Gaza, issues relating to torture, issues relating to juvenile justice, and issues relating to the protection of the Bedouin people. I'm happy to note that Israel cooperated with the committee and submitted information within 1 year, although that information was not, and the replies were not found fully satisfactory at the time by the committee. And for that reason, the committee asked the state party to include the replies to its further questions as an addendum to the next periodic report of the state party, in addition to the replies to the list of issues prior to reporting. And I regret that such an addendum has not been added, but I'm sure that further questions on these issues will be raised today. In the concluding observations of 2010, Israel was requested to submit its 4th periodic report within 3 years. And that in itself was an indication at the time that there were serious concerns about the human rights situation in Israel within the committee. And once again, I would like to note how pleased I am that the state party has shown to be willing to comply with this request and to make itself once again accountable. And particularly in the situation in which we find ourselves today, and to which reference was made both by the Mr. Ambassador and the Director General, and that is that when the committee last time met with the delegation of Israel, it was in the aftermath of the Operation Cast Lead, the military offensive against Gaza from the 27th of December 2008 to the 18th of January 2009. And now we are meeting again, as was indicated by the Ambassador, in the aftermath of the 3rd round of violence in 6 years, the Operation Protective Edge, which lasted from 8 July to 26 of August 2014, and which started to unfold during the most recent session of the committee in July 2014, and which led to the killing of so many people, including 500 children, and to the displacement of tens of thousands of people. And of course, these hostilities give rise to a number of urgent queries and questions from the perspective of human rights. And I was pleased to note that the Director General indicated that the delegation is willing to answer to all questions that will be raised today in the course of our proceedings. And that, Mr. Chair, brings me to issue number 1, significant developments in the legal and institutional framework. And once again, I'm grateful for the information given in the report and in the oral presentation today. And I was particularly pleased to read that Israel has ratified the Convention on the Rights of Disabled Persons. But I have a few further questions which I think fall within the wide remit of issue number 1. And the first is whether Israel is considering, and if so, whether it has taken any steps which would lead towards the ratification of optional protocol number 1. And I'm raising that particular question, optional protocol number 1, which is the optional protocol relating to the mandate of the committee to deal with individual communications. It's a question we raise with every state party to the covenant, which is not yet a party. And we raise that question because experience around the world, including my own country, the Netherlands, has shown that the recognition of the rights of individuals to submit complaints about alleged human rights violations to regional or international judicial or quasi-judicial bodies, of course, after the exhaustion of all local remedies, has significantly contributed to the strengthening of the protection of human rights at the local level. And I can say that this committee would welcome Israel's accession to the optional protocol. Secondly, I think we are all aware of the fact that this year we are celebrating the 25th anniversary of the second optional protocol, which is aimed at the abolition of the death penalty. And it would be, I think, very important if also Israel would consider accession to this protocol, in which a further elaboration and substantiation is given of that basic right, the right to life, protected by Article 6 of the Covenant. And it's also the practice and policy of our committee every time that it meets with a delegation of a state party to raise the issue of reservations. And Israel, of course, still has one reservation to Article 23. I'm wondering whether the state party is regularly undertaking the review of reservations to international human rights treaties in order to see whether the reservation can either be withdrawn or given a narrower scope, or whether it should be maintained by the state party, by Israel. That brings me to issue number 4, Mr. Chair, and that's the issue that was raised also in the presentation of the report, the issue relating to the repeated call by the Human Rights Committee on Israel to ensure that all persons under its jurisdiction and effective control are afforded the full enjoyment of the rights of the Covenant. And I think for the record it's important to recall what in its latest concluding observations of 2010 was said by the committee. It said that contrary to the states party's position in the current circumstances, the provisions of the Covenant apply to the benefit of the population of the occupied territories, including in the Gaza Strip, with regard to all conduct by the state party's authorities or agents in those territories affecting the enjoyment of rights enshrined in the Covenant. And we all know that this view is not only adopted by the Human Rights Committee, but has been endorsed by the International Court of Justice and has been followed mutatis mutandis by other human rights treaty bodies. We were not surprised, of course, but still disappointed that Israel is not accepting this particular position because it means that it leaves millions of people over which it is exercising effective control without formal entitlements to the enjoyment of their human rights and fundamental freedoms. And secondly, from my part as a member of this committee, I'm disappointed by the position of Israel, because by ratifying the Covenant, Israel has accepted the mandate of the committee to assess the implementation of state parties of their obligations under the covenant, and that, of course, implies the mandate of the committee to interpret the scope of the obligations that states parties have accepted. And on the issue of the extraterritoriality of obligations, the committee has done so explicitly also in General Comment number 31. And I was disappointed also because of the point raised by the delegation, by the state party in paragraph 48 of its report, in which it indicates that the basic principles of treaty interpretation imply that the covenant does not apply or was intended to apply to areas beyond a state's national territory. And I hope you would allow me to take issue with that particular statement, because I do think that those who drafted at the time, in the 40s and 50s, the Universal Declaration of Human Rights and the two other parts of the International Bill of Rights, the two covenants, knew what they were talking about, what they were drafting. The drafters at the time did not work on the assumption that states, by subscribing to international human rights instruments, thereby granted human rights and fundamental freedoms to those within their jurisdiction or within their jurisdiction. No, the assumption of the, may I call them, the founding mothers and fathers of the International Bill of Rights was that states, by subscribing to international human rights instruments, recognized the inherent dignity and the equal and inalienable rights of all members of the human family in all situations. And I refer you to the preamble and Articles 1 and 2 of the Universal Declaration of Human Rights and to the preambles of the two covenants. And that has led the committee, the Human Rights Committee, also in light of its long-time experiences with states parties from around the world, to crystallize its experiences in General Comment number 31, to which I already made a reference, and in which it said, and I'm quoting, "A state is responsible for all rights guaranteed within the covenant in all areas, within the power of effective control of the forces of a state party, acting outside its territory, regardless of the circumstances in which such power of effective control was obtained." End of quotation. And I would appreciate very much if the delegation would be willing to comment on my concerns. And that brings me to my final issue for this morning, at least, issue number 5, and that is the issue relating to that core principle of human rights, the principle of equality and non-discrimination, or to say that in other words, which I very much like myself, the principle of inclusiveness, the principle that human rights include everyone and do not exclude anyone. And I thank the delegation for the information given in the paragraphs 50 to 56 of its report, but I still have a few questions which are of a general nature, because some more specific questions will be raised in the context of particular themes today. First is, it is still not clear to me whether the Basic Law on Human Dignity of 1992 explicitly recognizes the principle of equality and non-discrimination. And my question is whether the delegation could clarify that particular point. And if that particular basic law does not explicitly contain that principle, that core principle, what obstacles, or to refer to the latest conversation, discussion, dialogue that we had with the delegation of Israel in 2010, what political considerations stand in the way of the inclusion of the principle of equality and non-discrimination in an explicit manner in the basic laws? In paragraph 51, that's my second point, the committee is informed that there shall be no violations of rights under the basic law except by a law befitting the values of the State of Israel, enacted for a proper purpose and to an extent no greater than is required. And my question is whether that restriction clause is complying with the very strict restriction clauses that are contained in the covenant, among others in Article 18 of the covenant on freedom of religion and on Articles 19 to 21 relating to the freedoms of expression, assembly and association. I would invite the comments of the delegation. And if possible, I would like to ask the delegation to give us an explanation how it has interpreted those terms, the values of the State of Israel, and the term for a proper purpose. And that brings me to a third question, and that is the question about the existence still of a number of discriminatory laws in the context of the state party, such as, I'm giving a few examples, the sectarian representation law, the election threshold law, the power plan bill. Of course, that's not a law, but it's pending. The contributors to the state bill, the Jewish national state bill, the foreign funding law, the anti-boycott law, the Nakba law, and the citizenship and entry into Israel law, which all seem to discriminate so much, either directly or indirectly, against Palestinian citizens of Israel. And my question is whether the delegation could indicate whether the existence or enactment of such laws is in compliance with the principle of equality, which I think is rightly be said by the state party to be a fundamental principle in the Israeli legal system. And then another question about the basic law, and that is that the basic law is set to protect the basic guarantees of personal liberty within the framework of Israel's Jewish and democratic character. I quote paragraph 51 of the state report. And my question is whether the delegation can explain the effect of this framework for the basic guarantees of human rights for its non-Jewish citizens. We have allegations in front of us which argue that such values are the basis of a legal framework that gives first-class rights and benefits to Jews, while second-class status is afforded to all others. Could the delegation comment on that? And then finally, Mr. Chair, on the issue of that important issue of equality and non-discrimination, I would like to indicate that we have information before us which shows that within its domestic legal framework, Israel maintains a three-tiered system of laws which accords different civil status, rights and legal protections for Jewish Israeli citizens, Palestinian citizens of Israel, and Palestinian residents of occupied East Jerusalem. Can the delegation explain how this is in compliance with principles of non-discrimination and equality and with its obligations under the covenant? Those were my questions in the first round, Mr. Chairman, and I'm looking forward to the replies of the delegation. Thank you very much.
Thank you, Mr. Flinterman. The next speaker on my list is Mr. Kalin. Mr. Kalin, you have the floor.
Thank you, Chair. I would like to join my colleague in welcoming very warmly the distinguished, very competent delegation. I've been asked to take up with the delegation issues number 2, 3, and 10. For reasons of limited time, let me refrain from asking questions on issue number 2. I had something more technical. So let's directly go to issue number 3, where we have asked the state party to provide information on new measures taken to disseminate and implement the committee's previous recommendations. First, I would like to welcome the efforts made since our last dialogue in disseminating all relevant documents in Hebrew and in Arabic, and to undertake the necessary translation work. I also welcome the creation of a joint interministerial team that was mentioned by Director General Palmore in her introductory remarks. In paragraph 39 of your report, you say that since its establishment, the interministerial team has, and I quote, made several significant changes in regard to human rights legislations. I would have two questions. First, am I right in assuming that the team cannot make legislative changes, but rather suggest such changes? Or does it really have the power to amend ordinances, decrees that fall within the purview of the executive, as seems to be suggested by your written answer? And second, regarding the several significant changes made since the creation of the team since 2010, could you give me some examples of changes that were initiated by the interministerial team with regard to legislations relevant for civil and political rights, and regardless of whether the recommendation had come from our committee or another committee? What are examples of such legislative changes regarding civil and political rights that were initiated by the committee? Third, I also welcome the interesting project initiated by the Minerva Center for Human Rights, enhancing cooperation with civil society. Director General Palmore seemed to suggest that this was a very positive experience. At the same time, I note that regarding many issues in the reports, there is a huge gap between the report and between reports submitted to us by NGOs. And I would like to know to what extent the government has been able to incorporate comments made by civil society into its own report as a consequence of this dialogue. Turning to issue number 10 on asylum seekers. Let me first highlight that we are not, of course, assessing Israel's obligations under the 1951 Convention on the Status of Refugees. However, we see adherence to the 1951 Convention, which is much more detailed as the covenant, as a means to fully achieve respect for Israel's obligations under our covenant, including the prohibition of inhuman treatment under Article 7, which enshrines a prohibition of refoulement, Article 9 on the prohibition of arbitrary detention, or Article 26 on non-discrimination. I would like to thank for the particularly comprehensive responses in the report and the details given. Because time is limited, I would like to focus on just 3 or 4 issues. You note the large number of illegal entries you had of asylum seekers, particularly from Eritrea and Sudan, and that there was a need to take measures, including building a border fence, which proved to be very effective, and including mandatory detention of what is called in the law infiltrators. Of course, I fully recognize Israel's sovereign right to control its borders and to prevent illegal entry. No problem with that. Nevertheless, I would like to know, do asylum seekers coming to the Israeli borders through Sinai have any possibility to apply for asylum at the border? If yes, what is the procedure for such asylum applications at the border? How many applications have there been since the fence was built? And in how many cases were asylum seekers allowed to enter the country? through in the aftermath of an asylum application at the border. If such possibility does not exist, either in law or de facto, if this is the case, then I would have two additional questions. Taking into account that the vast majority of arrivals from Sinai were Eritreans, taking also into account that you mention in paragraph 280 of the report that at least some, if not many, of these asylum seekers had been victim to ill treatment while transiting through Sinai. I would like to know first, how do you comment on the suggestion that rejection of such victims at the border may amount to refoulement as prohibited by Article 7 Covenant? Because it would mean that these people would remain exposed to the ill treatment on the other side of the border. Second, taking into account that we're mainly talking about Eritrean arrivals, how is the measure of closing the border to them compatible with the prohibition of indirect discrimination as enshrined in Article 26? Of course, at its face, the measure of closing the border is neutral, but it has a disparate impact just on one group of asylum seekers. And more generally, Israel is known for a particularly low rate of recognitions of asylum seekers as refugees. And again, we don't need to discuss your interpretation of the notion of refugee. What is relevant to us is, how can Israel ensure with such a very, very extremely low, it is said, one of the lowest worldwide recognition rates, how can Israel ensure with such an extreme low recognition rate that no rejected asylum seeker is returned to a country where he would be risk ill treatment or other relevant human rights violations amounting to a violation of the prohibition of refoulement as enshrined in our covenant? Turning to the prevention of infiltration law that was mentioned by Director General Palmore and is also mentioned in the report. Please allow me to express first some uneasiness about applying the notion of infiltrator to asylum seekers. The Oxford Dictionary defines infiltrators as spies, agents, undercover agents, plants, intruders, subversives. Asylum seekers are none of that, at least to the very large majority. One never can exclude some exceptions. But it's not really what I want to ask, it's more a remark. But a remark in light that, again, Eritreans have worldwide one of the highest acceptance rates as refugees. In Europe, more than 80% on an average. So we're really talking about refugees in most of these cases. But what I would like to know is the amendments and the judicial decisions regarding the law on infiltrators. First, of course, it has to be welcomed that the Supreme Court has taken effective measures, has twice declared amendments to be unconstitutional. This indicates that the court system really is functioning. It's also interesting to see what the rationale was. Lack of proportionality of automatic prolonged detention. This is entirely compatible with our own case law of this committee. Nevertheless, I wonder what led the legislator, the lawmaker, after the first Supreme Court decision to enact Amendment number 2, that despite the decision continued to provide for automatic prolonged detention, just shortened the period of detention. And second, what is foreseen now with the more recent Supreme Court decision? What will the law now say once the law as presently applied expires and what are the plans for the future. Then, regarding Sudanese asylum seekers, the report informs us that collective protection for Sudanese asylum seekers was lifted when South Sudan became independent, and I guess that's fair enough. However, since then, in South Sudan, an armed conflict has erupted, and I would like the delegation to provide me with information on deportations of South Sudanese asylum seekers now, looking at the new situation in that country. Finally, in question 10, we ask, please indicate which measures are taken to investigate cases of brutality and violence against asylum seekers by police and immigration authorities, and to prosecute those responsible. In your response, you provide very valid information about the so-called Sinai victims, about victims of trafficking, but this is not what the question wanted to address. Trafficking, I think, will be taken up in another context. In other words, the question was not answered, neither in the written nor the oral information provided to us, and I kindly ask the distinguished delegation to provide us with the lacking information during the course of today's dialogue. Thank you very much.
Thank you, Mr. Kalin. The next speaker on my list is Mr. Iwasawa. You have the floor, Mr. Iwasawa.
Thank you, Mr. Chairperson. I join my colleagues in extending a very warm welcome to the distinguished delegation of Israel. I will ask questions on issues numbers 6, 7, and 8. And I start with issue number 6, and first with subparagraph A on the punitive demolition of houses. The resumption of the policy of punitive demolitions is of concern. In 2005, the Israeli Military Commission found that punitive demolitions did not serve as a deterrent and recommended ceasing the policy. Could the distinguished delegation explain how the resumption of the policy corresponds to the findings of the Israeli Military Commission? According to your written replies, only in cases that the unauthorized structure is not demolished by the person who constructed the structure, the authorities will act to demolish it. In this regard, I would like to ask questions about the participation of the Palestinians and Bedouins in the planning and zoning process and their consent to demolition. What measures has the State Party taken to allow participation of the affected communities in the planning and zoning process? Could the distinguished delegation tell us whether public meetings with the local resident committee have been held concerning planning and zoning? We have reports that the Palestinians and Bedouins are compelled to give consent to demolition in the coercive environment as a result of settler violence, harassment, and the issuance of demolition orders. What measures has the State Party taken to remove obstacles to such consent being given freely? The punitive demolition raises human rights concerns, including prohibition of arbitrary interference with family or home under Article 17, the right of the family under Article 23, non-discrimination under Article 26, and prohibition of inhuman and degrading treatment under Article 7. Could the distinguished delegation explain how the punitive demolition is compatible with the Covenant? I move to subparagraph B on the construction of houses. According to information before us, the planning and zoning regime applied by the Israeli authorities makes it almost impossible for Palestinians to obtain building permits, while it facilitates Israeli settlers in the occupied Palestinian territory. The majority of Area C is not planned or zoned for Palestinian construction. In areas where building is not prohibited, Palestinians face difficulty in obtaining a permit due to a complicated application process. And according to information before us, under those circumstances, Palestinians are compelled to build constructions without permits. Moreover, we have reports that although Israeli settlers enjoy full participation in the planning process, Palestinians' participation in the planning process has been restricted by military orders. Could the distinguished delegation explain whether it plans to change the planning and zoning regime applicable to Palestinians in Area C? Does the delegation plan to allow participation of affected Palestinian communities in the planning and zoning process? I move to subparagraph C on the Bedouin population's right to ancestral land and traditional livelihood. I thank the distinguished delegation for giving us information on the work of the Advisory Goldberg Committee. Could the distinguished delegation explain how the committee's suggestions were reflected in the policies of the government, such as the draft law for the arrangement of Bedouin settlement in the Negev? According to information before us, Bedouin communities who reside in the West Bank are particularly at risk of displacement as a result of demolition and eviction orders. Could the distinguished delegation explain whether it has a plan to hold the issuance of demolition and eviction orders relating to the Bedouins in Area C? The majority of Bedouins have expressed opposition to being relocated and concentrated into 3 urbanized townships, as it would destroy their traditional economy and rural way of life. What is the purpose of the transfer plan to relocate Bedouin communities in the West Bank? Are there plans for expansion of the Israeli settlement in the E1 area? If so, could the distinguished delegation explain the reasons for such expansion? I move to subparagraph D on the Bedouins and Palestinians' access to health services, education, housing, water, and sanitation. According to information before us, the Bedouins have a shortage in the supply of basic amenities such as water and electricity. Could the distinguished delegation explain what measures are taken to ensure essential services to the Bedouins? In particular, what measures are taken to guarantee Bedouins access to health services, water, electricity, and other infrastructure in unrecognized villages? We have also reports that the Palestinians are evicted from their agricultural lands, which impacts their livelihood and access to food. Could the distinguished delegation comment on the reports? I now turn to issue number 7. I thank the distinguished delegation for giving information on the efforts being made to provide public services in different languages. I would appreciate it if you would give us additional information in this regard. What proportion of the medical staff speaks Arabic? What is the percentage of Arabic citizens in the civil service? Do all the ministries accept documents in Arabic? According to information before us, the Nakba law of 2011 authorizes the Minister of Finance to reduce funding or support provided to an institution if it holds an activity that contradicts the definition of the State of Israel as a Jewish and democratic state, or that commemorates Israel's Independence Day as a day of mourning. Could the distinguished delegation comment on the effect of this law on the Arab minority? In the list of issues, we asked to what extent the State Party has been promoting cultural rights in Israel and occupied Palestinian territory. I'm afraid that this question remains unanswered. I would appreciate it if the distinguished delegation would provide an answer to this question. I now turn to issue number 8. I take note that Ms. Parmore, in her introductory remarks, mentioned an improvement in the rate of employment, especially among Arab women, an improvement in the level of education of the Arab population, and an improvement to the public transportation serving Arab localities. I also take note that the Ministry of Education sees the employment of the Arab population as a prominent issue on its agenda. I welcome these developments, and I urge the government of Israel to strengthen its efforts with regard to these challenges. According to your written replies, the number of Arab women employed in the civil service has increased. This is also welcome. However, the representation of Arab women in the civil service is still far from satisfactory. Arab women face compound discrimination of their background and gender. Could the distinguished delegation comment on the possibility of taking temporary special measures for Arab women? According to information before us, during Israelis' military offensive in Gaza in summer 2014, there were numerous claims by Arab workers and students who faced dismissals and threats of suspension over their publication of anti-war views. What actions has the State Party taken to address this problem? Thank you very much, Mr. Chairperson.
Thank you, Mr. Osawa. The next speaker on my list is Mr. Vatsalashvili. Mr. Vatsalashvili, you have the floor.
Thank you very much, Mr. Chair. Let me join my colleagues and warmly welcome the distinguished and, as Mr. Kellen mentioned, highly competent delegation. Let me address questions under issue 9 that deals with the concerns that Palestinian population is experiencing problems in accessing natural resources in general and agricultural land and adequate water supplies in particular. In the report, the State Party provided details of the accomplished and ongoing construction works designed to improve the water supply and sanitation system in numerous areas and locations. International humanitarian law establishes obligations concerning inter alia respect for and protection of real and personal property and management of public property, including natural resources. And it has been encouraging to read that significant investments are made in order to improve the conditions, the living conditions of the population. Also, as report indicates, there are some areas where the system is not functional yet, or due to technical reasons, not all residents can be connected to the water supply system. In its previous concluding observation, the committee expressed concerns regarding the water shortages that disproportionately affect the Palestinian population in the West Bank. The problem was reportedly is further exacerbated by prohibition of construction of wells by the Palestinian population. It has been also reported that authorities withhold approval of projects submitted by the Palestinian Authority and that the military destroyed unlicensed Palestinian agricultural wells, particularly in the Jordan Valley area and the area of the West Bank, without providing viable alternatives to the population. And on this background, let me ask the distinguished delegation to inform the committee if these construction works benefit Palestinian population equally with that with the Israeli settlers, whether it would be possible to allow to construct or maintain wells that would satisfy needs of the population, of that segment population, which cannot, for some reasons, be connected to the water supply system at the moment. Back in 2010, this committee also expressed concerns regarding the frequent refusal to grant agricultural permits to Palestinians, and in particular to the segments of population residing in the so-called SIM zone, in order to access the agricultural lands on the other side of the wall. Unfortunately, the report submitted contains no information on this issue, and obviously it will be very interesting and useful for the committee to get more updates on that. It has been reported that only a few, 8 or 9 gates out of the available existing, up to about 90 as far as I know, operate in a proper way, especially, and that creates problems, especially during the period of harvesting. Although the number of gates, again, is reported to increase at that time, but still the problem is there. As a result, and the number of permits issued, especially again during the harvesting period, decreased due to the more tightened security regulations. And let me give you just one example, which was cited by various reports of the NGOs, and this is a village of Bodrus near Ramallah. The fence, the wall which separates the village from the farmlands there, been a reason for a frequent and permanent, I would say, regular, rather, protests by the villagers. And final question is related to the issue of seizure of the land by the military. Is it correct that if decision is made about the seizure of the land on a security grounds, the leave is granted to the landowners so they can submit an appeal to the military commander and negotiate the terms? If the appeal is denied, leave again, and so it was reported of a leave of 1 week, is given to the landowners so they can petition the High Court. So my question is it a standard practice to provide the compensation in cases of a land seizure? How frequent are such appeals to the court, and how often the compensation is being provided? And taking into account the general restrictions imposed on movement, and again, reportedly about the time period provided for the appeal, to what extent one could be satisfied that the judicial system is accessible for those affected by the seizure? Thank you very much. This is all.
Thank you, Mr. Vatsilashvili. The next speaker on my list is Ms. Vatafal. Ms. Vatafal, you have the floor.
Thank you, Mr. Chair. Let me also extend my warmly welcome to the distinguished delegation. I am going to ask questions on issue number 11 and 12. Regarding issue number 11, the principle of equality between women and men, we have taken note of the legislation, administrative, and other measures to the advancement and promotion of gender equality and the promotion of women's rights. We would like to welcome the efforts you put in increasing the rate of women in decision-making positions. We urge you to continue with these efforts. And yes, I remember Golda Meir. I know that she is the first female prime minister. I don't know if she was the last one, but we will highly welcome the second female prime minister of Israel. I was also pleased to read that parental rights will not be provided automatically to mothers, because that was one concern of the men, the fathers. We also welcome the amendment of a women's employment law and your reply to the incident in Beit Shemesh, in that suspects were arrested. My question is, were they found guilty and convicted? And were the victims remedied, compensated? And of course, there are some concerns with regard to the women's segregation in national ceremonies and events. in public transportation and other public sphere. We also welcome the adoption of the recommendations of the interministerial team on this issue. But as you know, customs and traditions do not change overnight. How will this work in practice? Have you thought of awareness-raising programs? You have also mentioned a draft bill in this regard. Has this bill already been drafted? What is the name of the bill? And what is the status of the bill? With regard to the case of Vivian Al-Salem, I would like you to elaborate more on this case and explain to the committee the divorce procedures in Israel, because as we have reports that a woman can't get a divorce without her husband's permission. So maybe you can elaborate more on that. We would also like to know, and that is my final question on issue number 11, the number of female judges and female public prosecutors in Israel. Turning to issue number 12, I was not satisfied with the answer. So I'm going to read the questions. Can you provide detailed and updated information on the progress made to review the legislation governing the state of emergency and the declaration made under Article 4 of the Covenant? How does the state party refrain from using administrative detention and ensure that administrative detainees are afforded in practice all the fundamental safeguards, including the rights to have prompt access to a lawyer, to have an independent medical examination, to notify relatives, and to receive visitors? What measures have been taken to ensure that detainees are systematically informed about their rights from the very outset of their deprivation of liberty in the language that they understand and are promptly brought before a judge? I look forward to your replies, and I thank you in advance, and thank you, Mr. Chair.
Thank you, Ms. Waterval. I have two more speakers on my list, and we must bear in mind that the delegation should have at least as much time to answer the questions as we take to ask them. Mr. Zlatescu, you have the floor.
Thank you very much, Mr. Chairman, for giving me the floor. I want to take my share and welcome the distinguished delegation of Israel Shalom. An image aired on TV in 2006 has remained with me for years. It depicted Israeli, Arab, and Jewish families sharing premises and offering relief to each other in an Israeli shelter in Haifa during a rocket attack. And to me, that was enough proof that Israel is indeed at its heart, in both its civic life and laws, a democratic country, with one that has come out stronger, wiser, and richer after several battles with its neighbors. In its basic laws, Israel defines itself as a Jewish and democratic state. Israel is and has remained a representative democracy with a parliamentary system, proportional representation, and universal suffrage. In spite of its current issues, Israel is a developed country and a member of the Organization for Economic Cooperation and Development member, with the 43rd largest economy in the world by nominal gross domestic product as of 2012. Besides, your country has probably the highest standard of living in the Middle East and has one of the highest life expectancies in the world. It has ranked in several instances the only democratic country in the Middle East, and it has an elected government that is fully responsible to its citizens for its actions. It shares with the Western democracies a fundamental commitment to human rights, whose ties are reinforced by the common perspective on Holocaust as a triggering event in the contemporary evaluations of freedom. Presently, Israel has become an all-inclusive place Israel's ethnic diversity expanded in the 1980s and 1990s due to immigration. Several waves of Ethiopian Jews immigrated to Israel in the 1980s and 1990s and between 1990s and 1994, while Russian immigration to Israel increased Israel's population by more than 12%, we learned from recent statistics. Most importantly, Israel is a tolerant country where Arabs and Jews have found the motivations and grounds to coexist peacefully. If any individual acts of human rights violation occur, they are, I learned from your replies, promptly prosecuted and punished. After so many battles, Israel has remained and chose to remain an open society, accessible to the media of all countries. As an agora of debate among competing religious doctrines and ethical views, individual human rights violations are put under the magnifying lenses of public scrutiny. Often the most reliable critics of Israel have been the Israeli citizens themselves, with their communitarian idealism. And here comes my first question. Unfortunately, Holocaust survivors, many of whom have been pioneers in building the state of Israel and soldiers in defending its borders, are now passing away. Many educators in Israel are struggling with the challenge of how we shall remember the Holocaust without survivors among us. Yes, end of the quote. They are also asking, what goals do we want to transmit to the next generations? How do we want the story of the Holocaust to impress upon students' individual consciousness? And what impact do they, as educators, want it to have on the learner's identity as individuals and the collective? How does the imperative to remember apply to the individual and to humanity as a whole? Last but not least, should Jewish educators relate the study of the Holocaust to other genocides and contemporary events? Has the Holocaust education been in any way advanced in relation with the human rights norms enshrined in our covenant? Alarmingly, young generations are slowly forgetting the historical elements of the Jewish tragedy, and I think, together with my colleagues, that in Israel, first, the theme of Holocaust should be discussed and introduced in ways that stress on its ethical significance for the whole world. How are contemporary Israeli educators answering this major challenge of our new century, fringing on either forgetfulness or on moral reductionism? Implicitly, I think this matter also touches on the spirit of our covenant, thus I have put it first on my list. On 6, especially on 6D and 11, which I find tied up, on women's health, I'm citing from yesterday's Jerusalem Post. And it's the first time when I'm reading Jerusalem Post, yes? Representatives of Ichilov Hospital in Tel Aviv confirmed on Sunday evening that they treated Hamas leader Ismail Haniyeh's daughters. The hospital said that Haniyeh's daughters had been admitted for a number of days, noting that she was one of over 1,000 Gazans that the hospital treats every year. End of the quote. Indeed, this is humanitarianism taken above and beyond the logic of clash. It is known that upon request from Palestinian physicians, Palestinians in need of emergency treatment and surgeries are normally accepted into Israeli hospitals. And here comes my first question. What has Israel done today to ensure that the Bedouins and Palestinians' access to health services, health education, adequate housing as well, water and sanitation has been satisfactory? Have at times medical emergency rationales prevailed over the issues of territoriality and extraterritoriality in the application of the Covenant's provisions? Now I would like to place emphasis here on a different aspect, which relates to the first. At times, limited access to rights and resources have been distressing outcomes in the lives and rights of Israeli women of Arab descent. Often confronted with patriarchal customs and male-controlled rules reflecting the gender hierarchy in their culture, and as belonging to an underdeveloped yet distinct minority, Arab women citizens of Israel struggle with marginalization on many grounds. This brings forth some important concerns in the area of healthcare as well. Studies recurrently indicate that Arab women mark poorer than all other social groups in various health indicators, comprising access to obstetric and gynecological services. Having made it to the clinic, Israeli Arab women are confronted with unexpected expenses sometimes, to which one should add language barriers and cultural barriers as well, which I think are determinant in their marginality. How does the Israeli government plan to integrate citizens of Arab descent, especially those living in marginal area, in its updated healthcare plans, avoiding cultural barriers and including perhaps the building of new infrastructures? Thank you very much.
Thank you, Mr. Zlatescu. And the last speaker on my list is Mr. Fatala. Mr. Fatala, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, my question is related to the number of issues raised already by my previous colleagues, and focusing in particular on the implementation of Article 1 of the Covenant, either by annexing Palestinian land in the West Bank or depriving the Palestinians from access to their natural resources. A recent example which combined both, I mean the annexation and depriving the Palestinians from their from access to their natural resources, is that of annexation of almost 1,000 acres of land on 31st of August this year, which will prevent the Palestinian community of Wadi Fukin and surrounding villages near Bet Lahm from accessing their land and natural resources, in particular the access of the affected villages to water springs and water wells located in the area will be increasingly restricted. This policy of illegal annexation of Palestinian land and in the West Bank and the inaccessibility of the Palestinian to their natural resources constitute a clear violation of Article 1. Please explain and clarify this issue. Thank you, Mr. Chair.
Thank you, Mr. Fatala. That's the end of the interventions from the list of speakers. At this point, I'm going to suspend the meeting for 15 minutes to give the delegation that time to concert its responses. I stress concert rather than discuss the content. There won't be time for that. So we come back together at 11:45. The meeting suspended.